Hi, I'm Kim Simmons. I'm CEO and founder of Law 365. Today I wanted to talk to you about project delays. They're very important even at the best of times. So what happens at the worst of times when COVID-19 affects you? But also just generally speaking, how do you protect your situation of a project delay in a contract? There are two case scenarios that you need to be aware of. When the project delay occurs because of your fault, and when the project delay occurs because of a customer fault, a third party fault, or something like COVID-19 that's outside of your control. Let's take this last scenario first. So the project has been delayed and it's because the customer has delayed it, or COVID-19 has happened, or a third party has not done what they're supposed to do, and you're just managing that third party. In your contracts, if you don't already have these carve-outs, you really need to include a carve-out that says that any failure to deliver that is caused by an act and or omission by the customer or third party, or a force majeure, which would be for COVID-19 issue, then your responsibility falls away and your liability falls away. Okay, so this is the first thing you need to think about with your contracts. The second scenario we talk about is when it is your fault. That becomes a bit more complicated because there's no one else to blame. So you have to look at what is it that you can give at that point to the customer. The customer will ordinarily try to get as much from you as possible. And indeed, if you look at some customer terms and conditions, they'll put a very aggressive remedial process in place. They'll say things such as, we want to terminate, we want you to pay for replacement supply costs, we want you to pay for wasted management costs, internal costs. They'll try and put all the costs on you. And this is just for one failed delivery. So you've really got to pay attention to this. You don't want those kinds of onerous financial obligations on you when you've innocently missed one particular delivery. So what can you do? The very, very best thing you can do is to completely get rid of all the remedies and just rely on a right of termination. But I wouldn't do that for just one failed delivery. I would ask them, could we have maybe 6 failed deliveries, maybe consecutively, before that even kicks in? So that's your first point of the negotiation. The second point is if they say, no, we do need some financial remedies, then you can go into that, but you've got to be really careful, okay? You've got to make sure you've got, it's not a very quick case for them to get these remedies. It's got to be many missed, deliverables, things that will start to get the customer angry, okay? Then it becomes a bit more fair and equitable to provide some financial remedy. And if you do that, make sure you get rid of the indirect costs, such as the wasted management costs, internal costs. They don't need that. That's part and parcel of working with a supplier, okay? The things that you can potentially give is partial cost to a replacement supplier, which enables them to transition, and you can cap that. Please make sure you cap this so you know that your financial risk is a certain amount. You can even cap it at a percentage of the actual contract value, or you can just cap it as a monetary amount. So you can say up to £8,000, for example. And that allows all parties to say, right, we've got something for this. We know that the supplier is incentivized to not fail because they've got this incentive, and the customers is a little bit happier. They can go back to the stakeholders and say, we've got a good deal. I hope that's helpful. If you want more information, I've written a blog about this, which goes into a lot more detail than we have time today. And thank you very much for continuing to watch my videos. Thank you. Bye-bye.